Hey Brendan, it's Thursday. I had a really great time doing the reunion video with you last week, even though we couldn't vote for Star Wars. It drove me crazy. As one of the best things, I do think Star Wars was one of the best things about 2015. Brendan, I headed into this video with the idea that I would talk about mandatory minimums and how they need to be improved. But Brendan, as I studied the facts of the case more and more, I came to realize that this is not really a legitimate viewpoint. The whole thing is very messy, muddy, complex, and pretty terrible. I'm normally a big seeker of what's true and what's important and trying to find the facts in this case, but the facts in this case turned out to be so horrifying that I actually felt sick to my stomach. I'm not really sure where I'm going to go with this video because I don't know if I want to tell everybody what is going on here, but I am going to provide some of the evidence that I did uncover. I don't know if I'm going to provide all of the evidence. I want to stress at the very get-go that I'm still against mandatory minimums. I think it's a way to perpetuate a cruel and unjust system. Since about the 1970s, the Hammonds, Steve and Dwight Hammond, have been fighting federal government agencies in order to protect their land. Now, this isn't a literal protection of their land. They're not fighting off with guns or anything like that. But I do think an objective look at what's going on here, we can say that the federal government has acted to drive these people from their ranch. Whether or not that's in the good of the federal government or in the eyes of the people is a whole nother issue, and I don't really want to get into it here. In the early 2000s, at various different points, the Hammonds lit fires on their land in order to fight other fires and to take care of an invasive plant species. It seems that the federal government's argument that it was used to cover up an illegal deer hunt isn't substantiated by the evidence. No carcasses were found and no hunting evidence was made available. At this point, Brendan, I was feeling pretty good. I felt like, aha, I finally figured it out. It's clearly a case of the federal government stopping all over conservative rights. And while that may be the case, there are some facts that have been left out from this conservative side of the story. It is a fact that the Hammonds did do real damage to federal property. One can argue that there are mitigating circumstances. They lit a backburn in order to prevent more damage to their property. But the fact does remain that the Hammonds did violate a statute of United States law. The United States law in question is the Anti-Terrorism and Effective Death Penalty Act. Initially, conservatives call this whole thing ridiculous because these people have been accused of being terrorists. I don't see anywhere in this law, Brendan, where one person is labeled as a terrorist. The law merely has to do with the facts of the situation. In this case, about $1,000 worth of damage was done to real property. When I say real property, I don't mean like that it's actually their property. I'm talking about land that the United States owns. One can argue that it was just a mistake or it wasn't a big deal, but the fact remains is they did violate the law and they did violate a federal statute. Federal officials appropriately charged somebody with a crime who did in fact commit a crime. Now, it's not popular to think about this, Brendan, but our justice system doesn't work on whether something's morally right or wrong, but whether it follows the operations of the law. District attorneys, judges, federal prosecutors, state, local, county attorneys, attorneys general, they're all required by law to do certain things. While they have some discretion as to whether or not to charge somebody with a crime, it's only in the cases if it would be deemed a massive waste of resources. Even in these situations, sometimes they still have to charge somebody with a crime if there's enough evidence. And sometimes it gets more complex because the issues of the prosecuting party are sometimes taken into account. One of the things a lot of people don't understand about the law is that when an attorney takes on a client, it is their job to advocate as hard as they can for their client. At every turn, the attorney is supposed to fight as hard as they can for their client within the bounds of ethics and the law. At no point is the attorney supposed to decide what's morally right or morally wrong in the situation. They are focused on doing what they need to do for their client. In the assistant district attorney's case, that means the federal government. Doing damage to property of the United States is not in the interest of the United States, so it behooves the district attorney to do something about it and prosecute the Hammonds. Again, the assistant district attorney might literally think that this is crazy and stupid and that he shouldn't have to do it. But my point is, their job obligates them to do it. In this particular case, there was no federal overreach or malicious or vicious act. The assistant district attorneys were just doing their job and bringing suit against them. It's pretty clear from the evidence that the Hammonds were not tried by their true peers, that is, other ranchers. Ultimately, Brendan, the jury point is moot, though. Conservatives will tell you these were abuses of federal power, and maybe they are. But in this particular case, a plea agreement was struck before the end of the trial. The judge found the Hammonds guilty and sent them to prison. The judge, feeling merciful, decided to send them to prison based on the idea that it was cruel and unusual punishment to punish them for what was a relatively minor crime. But here we get back into the operations of our law. The courts have decided that, except in some very extreme cases, it's up to Congress to determine what is a cruel and unusual punishment. Length of sentence is rarely a factor in that case. While I understand the judge's desire to make sure there is no cruel and unusual punishment, precedent and case law is pretty clear here. In any situation in which there is a mandatory minimum which is written by Congress, it's assumed that it's not a cruel and unusual punishment. The Ninth Circuit appeal on this decision went on to list a long number of situations in which it seems fairly ridiculous the amount of trouble the person was put through as a result of their actions. Gentlemen being sentenced for dozens of years for stealing $120, men with low amounts of marijuana possession being sent away for prison for many years, and other such injustices. I want to stress here, Brendan, that the judge actually first listened to this case, wasn't doing his job. If he had been doing his job, the Hammonds should have gone to prison for 5 years each. I'm not saying that's right, I'm not saying that's morally correct, or that we need to have that sort of situation, but that is how the law operates. It's why his decision got overturned, and it's why the Hammonds are back in prison. The individual case was handled appropriately and correctly according to the operations of the way our laws work. But Brendan, literally everybody was doing what they were supposed to do in this situation. Conservatives like to say that the oppressive federal government labels these men as terrorists. There's nowhere in the language of the law that these men are considered terrorists. They're merely guilty of ruining some United States real property. The issue here isn't some sort of oppressive federal government crushing the little man. It's a fault with our own Congress and with us who have elected the wrong congressman. Mandatory minimums need to be pulled back. Mandatory minimums are not effective, they're not good deterrents, they're expensive, and they just don't work. Brendan, I gotta go. Jen and Al's out.